Greetings, everyone. Welcome. I am J Love, and I am your host today on Turning a Moment into a Movement. Um, and I also represent the Justice for Gerard Movement. Gerard is my son who passed away 2 years ago, but he was wrongfully convicted of a crime that he didn't do, innocent, and he went to prison for that crime. And because of that journey with him and all the people that I met on that journey, we created this platform called Turning a Moment into a Movement, where we come here every Friday or most Fridays to talk about wrongful convictions, to discuss injustice, and to educate, inspire, and also to bring hope. Um, our mission statement is to bring awareness to the wrongful conviction of Gerard and all others who are wrongly convicted, over sentenced, and medically ill and medically frail in our communities. To inspire, organize, and to educate all communities about the needs to disrupt systems, policies, patterns of the legal system, of the criminal legal system that leads to wrongful convictions. And so that's why we come here every Friday and we bring on some very awesome guests to give information out. Sometimes information that is hard to receive. So we ask you that you share these videos, and especially with those who are dealing with wrongful convictions. Share these videos, post them on your platforms. Speaking of platforms, I want to say hello to those who are watching on Facebook, YouTube, Twitter, Instagram. Hello, welcome, and thank you for joining us. And those who might listen to this later, we have a great it's warm here in the Detroit, Michigan area, so like 90 degrees. So if I am stuttering a little bit, that's because I am not used to all this heat. I don't even want to get used to it. But anyway, I'm going to bring in Rebatia. I see she's in the queue, and so I'm going to bring her in so she can introduce herself. Rebatia, hello.
Hello, hello there, Jay. Oh my goodness, it has been a different kind of a day today. Beautiful out
Rebatia,
here
yes,
in Michigan. We've got rain and heat and rain and heat and rain and heat, and
yes,
we are so blessed to have this kind of weather. I'm telling you. So, I am the founder of the Choice Zone, and also where your choice matters. We help people grow in their business, really hone in on being their best selves and actually walking in their purpose, working in their purpose, being their ultimate selves to themselves because you got to love yourself before you love on everybody else. And so we do that. And as the co-chair for Michigan Coalition for Human Rights. Oh my goodness, we're really making some waves here in Michigan. And of course, one of the ministers for transforming love, community, and the Michigan chair for G100 Oneness and Wisdom. So if you want to connect with some women who are business owners and doing things for women in the community, please contact me. You can contact me at Tia Taylor at thechoicezone.com. And look, enough about me because whatever I'm doing, whenever I'm doing it, it's about activism, it's about doing what's right, it's about taking our communities back, it's about family, it's about love. And I'm so glad that we're here today, Jay. I'm telling you, this walk has been magnificent, and we've got some things coming up with Trisha. Actually, tonight she kicked off her series. I know we're going to talk about that. I won't belabor it anymore. So thank you again. I'm
we
excited
might as well
about our
talk about it.
conversation.
We might as well talk about it since you brought it up, Rebatia.
Okay.
Here's the flyer, you guys. Trisha is not with us tonight, but she's busy.
She
She's
working.
been, yes. If you guys probably seen her on TV all this week promoting the Juneteenth celebration in Ypsilanti. It's going on. I think it starts in, well, it already started.
Hmm.
Tonight with Drelle is the main attraction, and then they have Lady Sunshine and some other bands there. And then tomorrow, this is a whole weekend long celebration of Juneteenth in Ypsilanti. So if you guys are not busy this weekend, join us at the Ypsilanti Juneteenth celebration.
Yes.
Thank you, Revertia.
Beautiful. Yeah. Yeah. I mean, it's a
So
huge celebration. I mean,
it's huge.
it really magnifies every facet of our experience here in the United States in this America.
Yes, and it has
So
grown. It went from when she first started off to now. It's a
yeah,
big deal. So,
it's a big
yes,
deal. Yeah, yeah,
yes,
yeah, yeah. She's always out here speaking for um for survivors, uh, over survivors speak and survivors of wrongful convictions and survivors of life. You know, so
yes. Gun
we thank you,
violence.
Jay.
Uh,
Yeah, we're behind you 100%. We'll be
yes.
out there. We will be on our way.
And also, we had to also bring up that Trisha and Alexandria joined
Hmm.
us yesterday at the
Yeah,
Michigan Coalition of Human Rights
yeah,
meeting. Um, and they're out now on the board. They're board members. So
yes,
congratulations to them too. They're tremendous. They do tremendous work, especially Ali and Trisha.
yeah.
They are really out here on the front lines of justice. So we're like, so I'm so happy for them. And yeah. And also we got an opportunity to see Pastor Barry, who was awesome. Awesome, awesome. If you guys I posted a video of him speaking at the meeting. If you get a chance to listen to it, you can see it on my Facebook page.
Yeah.
Pastor Barry is very inspirational. The work that they're doing at the Church of Messiah is
Hmm.
phenomenal. When you're talking about community based, community center,
Yeah.
um, Church of the Messiah over on East
Yeah.
Grand Boulevard, doing a huge, phenomenal outreach of the community.
Yeah.
So, welcome
I'm so
to
excited.
yes, to watch the video and check out, Pastor Barry. I know he's on social media as well.
Yeah.
So, Attorney Max said he's running late, but he will be with us. So
Okay.
we're gonna bring on our guest who is not new to us, but true to us. We're gonna bring him on right now,
Yeah.
Mr. Abdul Hakeem. Hello.
Good evening. Thanks for having me, Jay. Hey, Reverend Tia, how are you?
Wonderful. How you doing?
Always a pleasure to be here to make some noise.
Yes.
Yes.
So,
Uh,
welcome. I know you're not new, and people who watch us, you've been here with us for I know for the past 2 years, but or 3 years, or however long we've been on. I gotta go back and really check out Reverend Tia, how long we've been here. But introduce yourself,
Yeah.
Mr. Abdul. Let everyone know what it is that you do and how they can get in connect with you if they need to.
yeah, my name is Abdul Hakeem. A lot of people, know me as my birth name, Roberto. I am a paralegal in the Detroit area. I've been a paralegal since '95. I have a wide range of background. I did some bankruptcy law, corporate law, civil appeals, and family law over the years. I never worked for a criminal defense law firm, so I pick and choose the criminal cases I have worked on over the years after we cleared conflicts at the firm I worked with. Um, and those cases, they intrigue me, they interest me, and because of the justice issues behind them, more so than what I've ever seen in the corporate and the bankruptcy area, because you're talking about people's lives, right? And you're talking about safeguarding the presumption of innocence and all of our fundamental rights. And to me, that is so important. That is because we live in a society that emphasizes freedom, right? That we have the freedom to vote. We have a lot of opportunities. We theoretically, this is a free country. So when you take my liberty and you restrain me of my liberty, and you say that I'm entitled to due process of law and a fair trial, and these things aren't happening, it should stir people to revolt in a civil way, if you will, and it should stir the legal profession to get more involved. You shouldn't just have one paralegal or attorneys here and there. They should really throw their might against this. So that's why I do like I said, I don't do criminal law on a full-time basis or where I work at, but there are some cases, and one of them I want to talk today, where I feel so strongly about a person's innocence. And even in cases where I don't feel as strongly about a person's innocence, if it's clear to me that there were so many unconstitutional violations that resulted in their conviction, I like to get involved.
Yes. And I also want to add that you're also known for the brilliant work that you did on behalf of Devontae Sanford. And if you guys are not familiar with the wrongful conviction of Devontae Sanford, please Google it. 14-year-old who was wrongly convicted in Detroit for a murder that he didn't do, spent almost 8 years
8 years.
in,
I'm sorry, go ahead.
in prison for that crime. And you were a strong advocate for him
Right.
and for his family. And Devontae is home now, but um, that was some really groundbreaking. Um, I don't want to say groundbreaking, but it opened a lot of our eyes to the wrongful conviction and the injustice that goes on in this community. So
Yeah, as you said,
Um,
I was more of an advocate for him. I didn't work on the legal side. He had a fantastic legal team that sprung him from prison. But I was I was a court monitor in that case. I did get a lot of the pleadings for my own education. And as I learned more about the wrongs that happened in his case, I held several rallies for him. I met his family. I met his mother personally and stuff. So we were out there really trying to galvanize the community because of his age. That's what made his wrongful conviction so horrible, so much more egregious than a lot of these other cases. I mean, anybody who's innocent and goes to prison, whatever their age, it's wrong. But what they did to that kid is so unconscionable. It's so unconscionable. And while the story was played out in the news, there was this numbness in the community. The community would not revolt, it should, but but now we have programs like yours, thank God, that is a source of information for the community. And we do have, we are hearing about these cases, which is a good thing, and we need to keep that alive. But yeah, the whole, what was so upsetting about that young man's case, they had the evidence of his innocence 2 weeks after he was sent to prison. 2 weeks. And for 2 weeks, their arrogance would not allow them to confess mistake or confess wrongdoing, if you will. They fought to keep him in prison for 8 years, despite the fact, and when I say they, I'm talking about that prosecutor downtown. She had all of this evidence, and she fought to keep him in prison. And she changed her theory about, well, he must have helped the hitman. But no, that wasn't your theory when you induced him to plead guilty, number one. And number two, the hitman who gave a very detailed confession never mentioned that Mr. Sanford was his accomplice. He mentioned someone else, Nemo Davis. But anyway, I'm going too far off on that. But it still upsets me what happened to here.
I know. It should be.
When we held rallies, we couldn't even get a handful of people.
Yeah.
While the concerts were sold out.
Right. And that's a whole conversation, Reverend, about how when we're talking about injustice, seems like it falls on deaf ear, or people don't want to connect with it. But when it's so blatant, we find everything else to do but stand up. And we have to, and before I say what we have to do, this is why these things continue. Because we don't say nothing, we don't do, or we're slow to react. We are numb to the injustice. But yeah, that's why we're here to open some eyes, bring this awareness. Hopefully people here not only in Detroit, but all through Michigan and outside of Michigan can, get this information and share it and open their eyes to it and educate themselves and, have the courage to stand up, to organize, because we can make a change. We can. We just have to be inspired and motivated to do it. And so,
yeah,
and the key is not to forget. I'm sorry, Abdul. The key is not to forget, because Abdul, you said how it upsets you still today, because it's still upsetting today. It's upsetting just as it was before, because it shouldn't have never happened.
It should not.
And that's what we're trying to hone in on, is that these things should not have happened. And yet, after some time, we become lulled or distracted by something else going on in society, neglecting what the real confusion is, what's really happening, and how we really need to respond. We can't forget.
Anybody who has a son or a daughter 14 years old or younger, can you imagine if that was you? Because this can happen to anybody. Devontae Sanford just happened to be the one that day. It could have been anybody. So,
and the psychological trauma that I'm sure he continues to live with. Every time I talk about the case, I say a prayer to myself and say, keep your calm. Just put the facts out there. Don't get upset. But but it is upsetting. And, you know, I'm a professional and I like to behave that way, and there's a place and time for it.
Yeah.
But you think of the PTSD.
Yeah.
You just stop and think when a 14-year-old is going through the prison system, and we can start to think of all the horrors that go on in there. He was tortured in there. He was
Yeah, he
abused.
was.
He was physically beaten and tortured. He went in there with mental issues, if you will. And I don't say that to demean him, but he came out, right? You can imagine his mental state when he came out. Not just him, a lot of these defendants who aren't getting treatment, who didn't get treatment in there. The treatment they got in there was physical and verbal abuse. And after a while, you develop a PTSD. When, like you said, this should not have happened, especially to a boy, a 14-year-old innocent kid. And to think that the person who did this is still being re-elected, being put back in office. And she's heralded as a hero. There was no accountability. Not only for what she did to Devontae, but what she did to a lot of other people and what she continues to do. One story I'm going to talk about today.
Yes.
I say she wasn't a hero. She did her job. She did her job, because a prosecutor's duty is to set the innocent free as well as convict the guilty. Don't stop calling her a hero. She's not a hero. She's doing her job, what you, the taxpayers, pay her to do.
Exactly.
And not just her. You know, the Detroit police, there's no heroes in that agency either. This idea of having picnics, it's okay to bridge the gap with community and police. But when I see people having picnic with some of the officers who sent people to prison, I'm thinking to myself, are you kidding me? So I take a more hard-nosed approach to this stuff. And that's why I don't have a lot of friends and I don't care, because the truth is on my side.
I know that's right.
Lord. You know what? And the truth doesn't have a lot of friends. There's an African proverb that he who speaks the truth has very few friends. If you want to live a lie, you go and be a groupie with all the people who love to live comfortably in their lives.
Mm-hmm.
So that's not what I'm about. So.
I know that's right. That's a postable. He who speaks the truth has no friends.
There's no friends.
Mm-hmm. That's true. So tonight we're going to talk about another wrongful conviction from Wayne County, Roosevelt Pettiford. I got an opportunity to read some of his case, and I'm going to let you introduce it, Mr. Abdul.
Yeah, Roosevelt Pettiford is one of the wrongful conviction cases in Wayne County that I did work on. And I got involved in that case in 2018 on a referral. And like all the other cases that I will give any effort to, his case did not involve any physical evidence that connected him to the crime. Those are the things I look for. There was no confession. It was a purely circumstantial case. He was convicted based solely on the testimony of a woman at trial who recanted her statements to police at trial implicating him. And I'm going to get into that a little bit later. Her two statements to police did not jive with the crime scene evidence, which proved she wasn't there. But the jury convicted him for a host of reasons that we'll get into also. But he was convicted of, let me give you a background of the facts. On November 1st, 2005, there was a drive-by shooting at a gas station in the north end of Detroit in the Woodward and Grand Boulevard area.
Mm-hmm.
The victim was a high-level drug dealer. Someone made an attempt on his life a week before that. So, and he had lots of enemies. Let's face it. He was in the game, okay, where you don't have friends when you're selling drugs. There's territory competition, everything else. And when he was killed, he had a bulletproof vest on him. It didn't stop. He was shot multiple times, so he had no chance. There were some witnesses at the scene, a teacher and some students at a car, sitting at a red light. And there was this woman. This is a very important witness. There was these were strangers going about their business who didn't know Roosevelt, didn't know the victim. Keep in mind, this was out in public at a gas station, 11:30 o'clock in the morning. So these witnesses had no motive to lie for or against anybody. So there were teacher and students sitting at a red light in a car. There was this woman who was walking by. All of them saw the murder. There was a gentleman who was coming out of an alley. He also saw the murder. That gentleman did not testify at trial. I'll get into that a little bit in a few minutes. The woman did not testify at trial, but the teacher and the students did. And the killer wore a ski mask and was a short guy. That was the only description that the witnesses could give. They couldn't give a facial identification because obviously if somebody's wearing a ski mask, you can't make a positive identification. And science proves that. No matter how well you know me, if I'm committing a murder and wearing a ski mask, you are not going to be able to say that was Roberto unless I have a distinctive walk or something. But you can't make a facial identification. No, despite all the times I've seen you in the past 3 years, Miss Love, if you're standing at a gas station, I'm standing 30 feet from you, and that 30 feet is important, how likely is it if you have on a ski mask and you're shooting at someone in the heat of all that, I'm going to make a positive identification and say, that was J Love. No witness can do that. And we also know that witness identification is what? Unreliable.
Unreliable.
So that was the only evidence the prosecution had at trial.
Mm-hmm.
But the teacher and the student couldn't say. They were, at trial, they could not pick Roosevelt out and say, yep, that was the shooter. That was him, and he wore the ski mask, but I know that was him. Nobody could do that. Okay. So, but there was one woman who gave 2 statements to the police hours after the killing, and that's a problem there, because if you think about that, she had time to make up her story. She wasn't at the scene when the police were there. She wasn't at the scene when the shooting occurred, but she told police she was there. And she gave police a description of the van involved in the shooting that she told the police it was Roosevelt's van. That's not what all the other witnesses say. I'm talking about night and day, not just a shade, a difference in the shade of color. She also told the police it was Roosevelt. He was standing out there. I saw him do it. She doesn't mention the ski mask because she wasn't there. The other witnesses did mention the ski mask. The other witnesses, importantly, also gave a height description that was not Roosevelt. They said that all of them consistently said the shooter was short. Mr. Pettiford stands at 6 feet, 5 feet 11, almost 6 feet tall. How likely is it that someone's going to describe someone standing at 5 feet 11 as a short guy? They're not going to. Even though witnesses can't give precise height descriptions, you can't. No matter how long I've known you, I can't say you're 5 feet 6 inches. I can't give that precise measurement. I can say she's short. I can say maybe she's medium height. I can say she's a little bit taller than 5 feet. But can I really say you're 5 feet 6? I can't do that. But if you see Roosevelt Pettiford, you're going to say, no way is he a short guy. He stands almost 6 feet tall.
Right.
The shooter was short and wore a ski mask. That's what the teacher and the student testified. Well, the teacher and the student didn't testify at trial. They saw the ski mask. This woman who was walking by coming from a cleaner's named Joyce Riley, she was at the scene and gave the police a statement. And she was the one that said that the shooter wore a ski mask and he was short. Well, why? So you're probably asking, well, how come if the shooter wore a ski mask, the teacher and the student didn't see it? Listen, from different vantage points, I can see things that you can't, and you can see things that I can't. And Miss Riley was closer to the shooting than anybody else. Hello. You don't have to have a law degree to figure that out.
Right.
That's why she saw the ski mask. Go ahead.
Right. And then I read also that he had on a hood.
The shooter had on because it was in November. It was starting to wear jackets. The shooter had on a fur hooded jacket and a ski mask. The teacher and the students saw the shooter wearing the hood. They didn't mention the ski mask because, again, from where they were, they probably didn't see it. All of this is happening real fast. He's shooting the guy and he's getting the hell out of there, right?
Right.
The woman who was standing on the corner didn't testify at trial because the police didn't use diligence to locate her. But you got to ask yourself, wonder why? Because they knew she would have come into court and told that jury that the shooter was short and wore a ski mask, and the jury would have had what? Reasonable doubt to believe it was Mr. Pettiford.
Right.
That's why the police didn't want to bring her to trial. They lied and said they tried to find her and they couldn't, and that she gave an address that doesn't exist. But let me tell you, Roberto drives by that address every day. It's still, the building still exists. And it was built in the 1970s. We did some background. We did our little investigation too. So what does that tell you? If the building was built in the 70s, the damn cop lied when he testified at trial that the woman gave them a fake address. He said the address didn't exist. He didn't say he went there and couldn't find her. He said it didn't exist. These are, again, this is an example of police misconduct, right? That contributed to these convictions. They kept a key witness away. They let a key witness slip away from trial because they knew, as she testified, she probably would have found Mr. Pettiford. The jury would have had reasonable doubt to convict him.
Right. And they relied on, and as I was reading, this lady was on her way to buy crack cocaine from the guy who was the victim of this situation.
That's correct.
And from what I read, when she heard the gunshots, she turned around and ran back away.
And I believe
so how can you see anybody if you're turning around, running away?
And that was her testimony at trial. That was called recantation testimony, which was believable. And why do I believe her? That's a natural reaction.
Right.
When you hear gunshots, are you going to walk into the gunfight or are you going to go the other way?
Right.
Most people are going to go the other way. I'm not walking.
Exactly.
She was heading to the gas station. She never made it there. But what she did was so fatal that it did convict Roosevelt. She gave 2 statements to the police, one statement was 3 or 4 hours after the murder, where she put the murder on Roosevelt. She lied and said she was there. She saw it. His mini white van was there. There was no mini white van. All the other witnesses said the van was a large green conversion van. But Yolanda Browning knew to say it was Roosevelt's van because she knew him to drive that van. You see what's going on now? And that it was Roosevelt. I saw him standing over Lamont. Lamont is the victim's name. And he was just shooting and firing away. She doesn't mention the ski mask. It's nowhere in her statement. Well, you got to ask yourself why. Because she wasn't there. If she was there, she would have known the killer had a ski mask. And secondly, she knew there would have been a problem with her identification because the jury would have thought the same thing. Well, how can you say it was Mr. Pettiford if he wasn't wearing a ski mask? And you're standing 30 feet away from the shooting. You can't.
Right.
I can't even identify my brother if he's wearing a ski mask and all dark clothing, which is what this killer had, if he's committing a murder. I cannot do it. I can't say, oh, that's my brother. You can't make. And so she made 2 statements. The first one was like three hours after the murder. She said she saw Roosevelt do it. The murder happened. It was sunny outside. It was 11:30 in the morning. So she gives the appearance that she was able to make this identification because it wasn't at night. It was in broad daylight, which it was, and that his white minivan was there, which was a lie. Her statements didn't jive with the evidence at the scene. She thought his van was there, but the other witnesses said it was a large green conversion van. Witnesses who had no reason to lie for Roosevelt because they didn't know him. But Yolanda Browning knew him, and she had motive to lie. Her motive was he was dating her niece. He allegedly was abusive to her niece. And yeah, that is a motive for people to lie on you. They shouldn't do it because they're going to look what happened. Evidence came in at trial, and I'm going to tell you how they came in. So the second statement she gave 2 or 3 days later, Detroit police approached her for more detail. Because they knew that the first statement, they knew that wasn't a white minivan there. They knew they had a problem with her first statement. So they went back to her home like 2 or 3 days later to get more detail, to get more information. And then the second statement, and guess what they do? So when they go back the second time, they showed her photos of the victim's gunshot injuries. Now, I know you're probably asking, well, why was that important? Why are you bringing that up? I'll tell you why I'm bringing that up. Because in the second statement, they show before she gave the second statement, they show her these photos. He had a gunshot wound to the eye. So they had her make that identification, even though she wasn't there, because they put that in her second statement. They asked her, the police wrote the statements out like they always do, which I think they shouldn't do. You shouldn't, okay. But they asked her, where was the victim shot first? And she said, in the eye. Well, they showed her the photo. That's how she knew to say that. And
Right.
and they took advantage of the fact that she was drug dependent. She was on crack, like you said. That's another thing that's wrong. Police take advantage of people who are high on drugs, who are drug users. They use the fear factor. They win their trust, and they put all this stuff down, and they told her, sign right here, and she did it. This is in the back of the police car. So the victim was shot in the eye. But again, she knew to adopt that statement in that written statement because the police showed her the photo. So she was not going to disagree with it. But it wasn't because she was there. But other thing is, the first shot was not to the eye, which proves, again, she wasn't there. That's what her statement said. The statement said the first shot was to the eye. The guy was shot like 15 times. It was overkill. The first shot was to the victim's back, as the medical examiner testified, and as Joyce C. Riley, this witness I'm going to tell you about in a few seconds, she also testified, consistently with the medical examiner, that the first shots were to the back. And you're probably saying, Roberta, why is all that important? That proves Yolanda Browning wasn't there when she said the first shot was to the victim's eye. And she only knew about that, again, because the police showed her the photo injury. This is how dirty Detroit police are. This is how rotten they are. If you're gonna fight crime, do it constitutionally, do it legally, and do it ethically. They didn't give a damn that they were trying to frame an innocent man. And yes, the cops didn't like Mr. Pettiford. He wasn't a choir boy, but he wasn't a murderer. So there was this long-standing animosity between Mr. Pettiford and the police in that area. And I'm not going to get into all about his background because he's not in prison for that. He's in prison for this murder he didn't commit.
Right.
At trial, Miss Browning took back everything she told police. She got on the stand and said, I lied. None of that is true. I wasn't there. Like you said a moment ago, Miss Love, she did tell the police, I was on my way up there to get some rocks from Lamont. When I heard this shooting, I ran back north on Horton Street. And that's a natural reaction. People do run away from gunfire. I don't know too many people who run to it unless they got a gun, okay?
Right.
Despite all that, what happened was, under a court rule, the prosecutor then had read both of her two statements into the record. And based on that, the jury convicted Roosevelt. They thought Yolanda Browning was lying because there were these allegations that Roosevelt threatened her, sent messages through third parties to her, that if she testified this was going to happen, that was the prosecutor's spin on some phone calls. I have a transcript of the phone calls. And again, if Mr. Pettiford would have done that, I wouldn't waste my time on this case.
Right.
If there's any physical evidence, including a defendant's confession from jail calls or trying to threaten a witness, I won't waste my time with it. Because forget whether I believe they're guilty or not, because I know we're not going to win.
Right.
The prosecutor made these allegations that Roosevelt tampered with her and he sent messages to her through third parties, and that was the only reason why she was recanting. The jury stupidly believed it and convicted him based on the prosecutor's theory that she's only recanting because Mr. Pettiford threatened her and we got the jail calls to prove it. Well, I'll tell you about those jail calls. Unlike your classic witness tampering where people try to threaten witnesses, you better not go to court and testify, or if you do, I'm gonna kill you and your family. None of that happened. In those jail calls, Mr. Pettiford was telling people, make sure she comes to court and tell the truth. Because I wasn't there. I was not there. I didn't do that. Now, in hindsight, yeah, he shouldn't have made those calls because, again, you got some very clever prosecutor who's going to put a spin on that like they did and tell the jury, there's our evidence of witness tampering. But he didn't say, you tell Yolanda Browning if she go to court and testify, she's dead, or you tell Yolanda Browning, I'll offer her $10,000 if she lies. No, he wanted her to go, and he wanted her to tell the truth. And now we know today that she did lie, based on the fact that her two statements didn't match the crime scene evidence. And we also know she lied based on this new woman who came forward after he was convicted and identified the killer as wearing a mask and it being a short guy, which Miss Browning never told the police. So we know she wasn't there today. And so does the prosecutor know that today. And so did Detroit police know that in 2005 when they were there at the crime scene. So forget the jail calls, because it wasn't a call where he confessed. That would have been stupid if he did. Or he threatened Miss Browning. That would have been stupid if he did. None of that. So based on the fact that the prosecutor read her two statements into the record, the jury convicted him. Fast forward 10 years later, Scott Lewis, as you guys probably have heard that name.
Right.
We hired him to go find this woman because we did have we knew from the homicide file that this woman named Joyce Riley was a witness, because a police officer wrote some notes. You know how when the cops talk to you, they're writing down, they write what you say, and it's on a short notepad. We also had her address, which the police lied said didn't exist. I drove by there the other day. It's a 14-story building at 14th Street and Grand Boulevard. It's not like they had to go down a rabbit hole and find this woman. And the building was built in 1978, so it did exist in 2005. Don't you think? Yeah. So Scott Lewis located this woman. She was living out of state when he found her in 2016. And he held several interviews with her. And again, she told him, yes, she saw what happened. And here's what she said: but I wouldn't be able to identify the killer because he wore a ski mask. Don't you think she's being honest?
Yeah.
Because she said what the point that I made: you can't identify someone if they're wearing a ski mask. I don't care how well you know them. But she didn't know Mr. Pettiford. This was a stranger going about her business that day. So Scott got some background information from her. Where were you going? And she said she was leaving the cleaners, and she was walking home. She was walking in the direction of her home, and she told Scott where she lived. We did some background on that. We did our investigation too, Detroit police. We found out through peoplefinder.com that she did live there, and through the U.S. Post Office that she did live there, contrary to the lie that the officer testified to at trial when he said she didn't live there. And by the way, he said that the address didn't exist. It was all lies. They didn't want her to testify because of that description of the shooter. So she gave Scott Lewis this background. He got an affidavit from her that spawned a lot of appeals. In 2018, Roosevelt and his uncle, who is also an attorney, they were referred to me by another inmate. I rolled my sleeves up. I got busy with the case. I was like, oh, holy cow, this is a good case. Stands a good chance on getting reversed on appeal. I took it through the appeals with them under the supervision of his uncle, who's an attorney. We got denied at the Court of Appeals. They just rubber stamped at the trial court's decision downtown. And by the way, this judge who passed on all this evidence, she totally didn't give it any meaningful consideration. She also mischaracterized the statements that this woman, Joyce Riley, made in her affidavit, which proves she didn't care. She didn't read this file. The Court of Appeals rubber stamped her. The Michigan Supreme Court, however, they reversed it based on all of this new evidence about this woman. And there was another guy who also identified the shooter by name. And how was he able to make a description if the guy if the guy had a mask on? He saw the guy removing the mask as he was running back to the getaway van. These are details the jury didn't know about, but they probably wouldn't have mattered anyway, because I have to be honest, I don't know how they convicted Mr. Pettiford, because there was reasonable doubt all over this case before anybody knew about Joyce Riley. There was no confession. And if the jury paid attention to Yolanda Browning's two statements, they would have concluded she couldn't have been there because she got the van wrong. She could have been there. She doesn't mention the ski mask. She could have been there because Mr. Pettiford is tall. But the jury never knew that there was a witness who described the shooter as short. because that would have caused some, hopefully that would have caused some reasonable doubt in your mind. If you see this, if you see Mr. Pettiford standing, you're going to say, no, nobody would describe him as short. and nobody's going to describe Roberto as tall, because I'm not.
Right.
So the Conviction Integrity Unit took the case in March of 2020. The case sat there for 4 years while they lied to us, while they caused trust issues to us, while they polygraphed him with this dirty polygrapher named Jim Hop. I know some of you people out there are listening and you've heard of this guy's name. He will set you up to fail your polygraph. And that's what they did with Mr. Pettiford, because I'm going to tell you something. After he polygraphed Roosevelt, he tried to get Roosevelt to confess that he committed the crime to him off the record, meaning that after the test was done. Roosevelt called me up and his uncle up and said, what the F is going on? This guy was interrogating me. And I was like, Roosevelt, he's a well-known polygrapher. Now you're making these allegations. You got to bring me something to believe that, because, it's only him and the polygrapher there. Needless to say, he failed Roosevelt, but we outsmarted the Conviction Integrity Unit. They underestimated us because we knew he was their hired prostitute. And we knew that we couldn't claim attorney-client privilege for them not to disclose the false positive polygraph result to the Conviction Integrity Unit, because they're the ones who sent him. This is the game that they play. But what they did, they underestimated us, because guess what we did? We went to a truly independent polygrapher way up north in Traverse City to polygraph Roosevelt. And as I anticipated, he passed. The Conviction Integrity Unit that everyone's got faith in and trusts, they came out swinging and were ready to deny Roosevelt in August of 2021 after Jim Hop got his hand on him. I got emails from Miss Valerie Newman herself threatening to deny relief. We knew their mind was made up 3 years ago while the file collected dust down there after they sicked Jim Hop on him. This is how dirty and underhanded those people are down there. They don't give a damn about innocence. It's a lottery system. Yeah, they released somebody the other day. Hello, you guys didn't hear about that? Because guess what? His attorneys were from the State Appellate Defender Office, which is another issue I've been raising. I tell everybody, the only ones getting released are those represented by Valerie Newman's friends at the State Appellate Defender's Office. Didn't hear about that in the media. But what I'm saying is, this is what they do. It's the lottery system. Your chances of getting struck by lightning are better than the CIU releasing anybody right about now. Hello? Because they're dirty. They don't care about innocence or justice. And they are getting political pressure from the bigwigs in Lansing to stop letting all these people out because it's costing the taxpayers money. So we showed Valerie Newman we're just as slick as she is. So he passed our guy's polygraph. And by the way, that guy up in Traverse City, his background rivaled Jim Hop's. And he was a former FBI agent, just like Jim Hop. And guess what? He and Jim Hop used the same polygraph machine. They asked Roosevelt the same questions. One of them flunked him and one of them passed him. And you wonder why polygraphs are not admissible in Michigan courts. This is because they're not scientifically reliable. And for Valerie Newman to rely on polygraphs, and she'll lie and say she doesn't, but she does, for her to rely on polygraphs when she herself as a defense attorney challenged them when she was at Sato, where her buddies were, is dirty. And as I told Roosevelt's uncle, they denied him in 2021. Their minds were made up back then. When Hop failed Roosevelt. And let me tell you something else about Jim Hop in case you guys didn't hear about it in 2022. It was all in Detroit media. So after Roosevelt told us about the dirty way that Hop tried to get him confessed at the polygraph, it didn't go anywhere because, you know, we couldn't prove it. But I didn't doubt Roosevelt. I said, this Jim Hop is a former FBI agent. You're going to trust the FBI? Worse than Detroit police. These are people who killed Imam Lukman, an innocent innocent man at a warehouse in Dearborn. These are
Right.
people who don't care about your property rights. These are people who don't care about your Miranda rights. They have a dirty litigation history. The FBI. They don't care about the Constitution. They think they're above all that. Do you know about their litigation history? They get sued by their own workers for discrimination and everything. These guys are arrogant. The FBI. Oh my God. I mean, you trust the FBI? It's gonna. This is what's going on. And the people that Jim Hop did pass, he got kickbacks. Don't hold me to proof. He's getting kickbacks for the few guys he helped get out to be nice. They're all political bedfellows down here. That's why we went way up north to get a truly independent polygraph examiner, because we knew Jim Hop was a prostitute for the Conviction Integrity Unit, for Wolf Mueller, and all these other bigwigs down here. And he passed Roosevelt. So we presented those results to the Conviction Integrity Unit. There's no integrity in it. And we said, now what? Now we have a result that rivals yours. And then Ms. Newman lied and said, I never said that the polygraph result was dispositive. Are you fucking kidding me? We got it in writing when you said it. Like we're stupid. That's the privilege in them. Don't you question me, boy. You just dribble, boy. You bean picker. That's what they think about me too. Don't you question my authority, and you got it wrong. No, I got it in writing from you, baby. What's up? I got it in writing. They can't. These are the people that you're trusting, and you wonder why no one is getting out. So here we are, the Conviction Integrity Unit. They denied him. Kim Worthy adopted the recommendation. I heard two stories. I heard they recommended Roosevelt release from one of his attorneys, because there were several other attorneys on the case. Then I heard that, well, I didn't hear. I saw in writing where they said they did not recommend to Kim Worthy that he be let go. This is the kind of confusion that they sow. They told one of Roosevelt's other attorneys they were going to recommend to Kim Worthy to let him go. And I don't believe I don't have a reason to believe that lawyer would lie about that. He's on the west side of the state too. He's not one of these political bedfellows in bed with these people down here. So he has nothing to gain by telling us that. So they did. They, meaning the Conviction Integrity Unit, did tell him, oh, we're going to recommend Ms. Worthy release him. But then when I saw some emails, I saw a different email that says something totally different. Now, I've been speaking English all my life, and I have a succinct ability to understand the English language, and I understand what it means when it says we are not going to recommend relief from judgment. So they did that. Kim Worthy denied relief, which is what she does in all these cases. And remember the last time I was on here, I told you all, she's very clever too, because she never gives a specific reason why she denies relief. Remember I said that? She does that. Because the cases are teed up for an evidentiary hearing. She doesn't want to box herself in a corner by giving you a specific reason that at a hearing you can challenge if they come up with another reason, okay? She just said, we're not convinced that the evidence proves by clear and convincing evidence that he's innocent. So what does that mean? Can you give me more information? She's not going to do it. These are the stories like Paul Clark, Roosevelt Pettiford, Ricky Rimmer, that the media and not just the media, a lot of other people out here that are busy praising Kim Worthy, they don't want you to hear about these stories. They go against the praise. They go against heralding her as a hero. So anything that goes against all that, you're going to have to get it from people like Roberto, Diane, and J Love on media that are not filtered, that are not sensitized with lies. And if I were here lying to you all, shame on me. I deserve punishment. But I truly feel strongly about this case. I truly feel strongly. We know how strongly I felt about Paul Clark. And look, the judge ended up letting him go. Kim Worthy denied him too. Strong evidence of that man's innocence. Overwhelming evidence, more so than some of those people she let go. So Roosevelt's case is coming up for evidentiary hearing this week. That's going to be a nasty battle. We suspect they're going to try to slide in that polygraph. We're going to come in with another polygraph. Hold up, wait a minute. Polygraphs can come in at evidentiary hearing, but they can't come in at trial. I know that too.
Mm-hmm.
Yes, you can't use them at trial, but you can use them at evidentiary hearings. And this is why the CIU demands polygraphs from people, because they can say,
okay, so wait a minute. You can't use the polygraph in trial. It's inadmissible.
They're not in Michigan
but
court.
For evidence, for the hearing on the evidence, it's admissible?
At an evidentiary hearing, yes, because the standard of review is different. At an evidentiary hearing, it's not proof beyond a reasonable doubt, right? Because it's not a trial. So you're not sitting in trial. And because polygraph results are scientifically unreliable, that's why Michigan courts don't allow them to be admitted in front of the jury, or if it's a bench trial, in front of the judge. I have known conviction integrity units, and even before conviction integrity units came along, where defendants and prosecutors would present the results of a polygraph to a judge who's deciding whether to grant a new trial. What it is, and I think it has to be by stipulation, both parties have to agree. I know I might be wrong on that, but they do come. I don't think they have to agree. The prosecutor can say, well, he passed the polygraph, Your Honor. So and we have all this other evidence that he's innocent. So based on that, we want to let him go. And of course, the defendant is going to live with that, right? Because he passed.
Right.
But if he failed the polygraph result, they can also bring that in at the evidentiary hearing and say, well, Your Honor, he also failed the polygraph result. It's not objectionable at an evidentiary hearing, because that hearing is to determine if you'll get a new trial. But think how how there's a paradox to that, right? Because a judge, even a judge will say, well, I didn't give the polygraph much weight. Well, you denied me a new trial.
Right.
And according to them, I failed it. Polygraphs, the reason why generally they're not reliable is because, like in Roosevelt's case, you had two polygraphers with the same background experience. They used the same methodology to polygraph him, and they asked the same questions. One passes him and one fails him. And we've heard that they say it's based on your heartbeat, your respiratory. But people who are telling the truth can also, like me, I'm telling the truth, and my heart's beating 100 miles a minute right now. but it's a subjective test. That's why courts don't allow them. What I mean by that, the polygrapher looks at the results and he concludes if you're lying or not. The machine doesn't tell him. He's looking at a graph. And he thinks it should have went up a little bit, and you would be telling the truth.
Right. So it's a matter of perspective of who's reading the polygraph results.
Yes,
whether you pass or fail.
Yes, it's a subjective test of the polygrapher.
Right.
It's not reliable because, and also the reason why courts don't allow them in at trial, because it's the jury's job to decide if you're telling the truth or not, right?
Right.
So this polygrapher is going to come in and say, yeah, I read these polygraph. He's an expert in giving the test, but I read based on my review of the polygraph results, he was being susceptible. They don't say lying. They would say, God, I don't know the language off, but his statements were susceptible to suspicion. In other words, you were lying, or something along that line. Or if they believe you're telling the truth. But the problem is Michigan courts see that as taking that function away from the jury. So that's why they don't allow them in at trial.
Mm-hmm.
I don't like polygraphs. If I had my choice, I wouldn't give them to anybody. And before I lose this thought. So about a year after Roosevelt complained about what happened to him, There was an incident in Oakland County in 2022. This was a high-profile case. It's a murder case where Jim Hopp, their star polygrapher in Wayne County, illegally and unethically disclosed some statements that to him to the chief of police in Troy, and the chief of police in Troy used that information to get a search warrant to search that guy's house, and based on evidence they obtained, he was charged with murder. Jim Hopp violated, in that case, attorney-client privilege because the defendant's lawyer hired him to do that polygraph. And polygraphers, a lot of people don't know this, are bound by attorney-client privilege not to disclose the results to any third party without that attorney's permission. But that's what Hopp did. It was in the Danielle Stislisky case in Oakland County. I don't know if you remember that case.
I remember that.
Yeah, the defendant's name is Floyd Galloway. So when I heard about that story, I thought back to what Roosevelt told me and his uncle that Hopp tried to get him to do at that polygraph exam a year prior. And we sent an email to the Conviction Integrity Unit and said, how can you use this guy after all the scandal that's come out in the Floyd Galloway case in Oakland County? And you're using him to polygraph people's loved ones. So now all you people out there listening, if Hopp failed your loved one, there's a very good chance he did that intentionally. The guy is not ethical. What Floyd Galloway was abominable.
Right.
This is the same guy that the Conviction Integrity Unit is recommending to people, and they're swearing on his honesty. Are you kidding me?
Right.
Guess what happened in that case in Pontiac? As a result of Jim Hopp's unethical and illegal conduct, the court suppressed all of that evidence that was seized as a result of that search warrant. It was called the fruit of the poison. You've heard of this fruit of the poisonous tree doctrine. And what that doctrine says, if police obtain incriminating evidence by illegal means, it's the fruit of the poisonous tree. They have to get a search warrant. The search warrant has to be based on probable cause. It has to be done right. It has to be done ethically. But what Jim Hopp did was unethical to his height. He knew what he was doing when he went to the Troy police chief and gave him that information. He knew that Troy police were going to get a search warrant and search that guy's house, and Hopp suspected they'll get evidence that linked him to the murder. Yeah, you did, but the evidence got suppressed because you're a scum. You're a dirty cop. You're a dirty FBI agent. You people are letting an FBI agent polygraph your loved ones. I know you can't, unless you can afford to get a polygraph done like we did for Roosevelt. We had to pay for that. But you better be careful when you trust the CIU and these attorneys saying, "Oh yeah, Hopp's cool. Hopp's cool" is the phrase I've heard by one of the attorneys. "Oh, Hopp's my guy. He's cool. You can trust him." Yeah. Well, you ask Floyd Galloway's attorney if he can be trusted. Ask Roosevelt Pettiford if he can be trusted. Because only a year after Mr. Pettiford made that allegation against Hopp, that story about what he did behind Mr. Galloway came out. And then I thought back to what Roosevelt told us, and I know Roosevelt wasn't lying.
It's interesting that because people always say, "I'll take a polygraph." They're volunteering for, "I'll take a polygraph," because we've been conditioned to believe that a polygraph will show your innocence. But again, that's subjective.
It's suggestive. And you could very well be innocent and flunk it. And you could be guilty. And guilty people have passed polygraphs. Some of those exonerees passed them. And some of them failed. Not all of them passed. But this is the problem with polygraphs. That's why I don't like the idea of using them. Now, your employer can, your employer can ask you to take a polygraph. Like when you're interviewing for a job, Michigan law allows that. But again, that's not a criminal case, right? That's not coming into court. It's done it helps the employer decide. Like if you're gonna, I think like banks, if you want to get a job at a bank, I think you have to take a polygraph. In addition to a very thorough background they do on you. Make sure you've never been convicted. They do a credit risk on you when you get some jobs. A lot of jobs do that now, but not all jobs require polygraphs, but they are required in some jobs. But that's different because it's not a trial. They're so they're admissible for investigative purposes. That's why police do polygraph people. It helps the officers decide whether to recommend charges for your arrest with the prosecutor. Yeah, they're allowed for investigative purposes, but again, they're not admissible at trial for these reasons. It's a subjective test of the polygrapher whether you're telling the truth or not. Who is he to decide I'm telling the truth or I'm lying? So,
but one of the good things that Mr. Pettiford did was to get a private investigator. You guys got the private investigator to find the lady, who was a witness, who they tried to cover up and hide this witness, said that she had the wrong. That's one thing that people should, listen, tap into. When you're doing this, instead of jumping for the polygraph, you might need to invest in a private investigator.
Oh, definitely a private investigator. If you know there's a witness out there who might have exculpatory information or evidence helpful to your case and who didn't testify at trial, even if they testified at trial, I mean, you want to be careful by having family members and friends approaching witnesses. It's unethical. It causes concern, right? That, your family member tainted this witness and had them say all these things. I've had that come up in some cases. It is always, and I always tell people, well, if you know this witness is out there, you know where they're at, don't approach them. Let your lawyer or a private investigator interview them. If you interview them, it's going to taint the process. And the prosecutor is going to, at trial, say, well, this witness is not reliable. The defendant's girlfriend talked with her and got her to sign the affidavit. He has a biased reason for helping him. It does come up. It does. Yeah. So yeah, if you, private investigators don't do it for free either, right?
Right.
So, the other problem is, a lot of family members and supporters, they don't have the money to hire private investigators and polygraphers. They're not cheap. Roosevelt, I've commended his uncle, who's thrown everything at this case and the appeals to help him in terms of the expenses, paying the polygraph examiners, paying the private investigators. But not everybody has that advantage, right?
Right.
What I recommend in that situation, if you don't have the money to hire a private investigator, still let someone who's not, who doesn't have a biased reason for helping you, because even with good intentions, we can do some harm,
right?
Without intending that result. So you don't send your family, you don't send your family member and loved one or boyfriend and girlfriend to go interview these people, because under that setting, they may feel compelled to give you what you want to hear. And I'm going to tell you something else. I've also seen where witnesses will come in court. In the Bob Bashara case, if you guys watched it like I did, Joe Gintz did this. He signed an affidavit that a prison writer prepared for him, and he read it. He got on the witness stand, and he recanted everything he said in that affidavit, and said he did it under duress. He did it under pressure, because the prison inmate knew what to put in the affidavit, because he read the file and said, "Here, sign right here." And that's what I did. I don't like witnesses who do that, and I know witnesses who do that. And I always tell people it's best to just have, what? I don't like typed affidavits typed by someone else either. It can cause a problem with the witness getting into court. And I've known some witnesses who do this also, saying, well, I didn't say it that way, and I didn't mean that. Well, you signed it, but you signed it, didn't you? Yeah, but I didn't mean it like that. That's the problem when you let someone else prepare the affidavit. You got an education, right? I mean, I always recommend, hey, here, write your affidavit out, write everything out that, and I'll get it notarized. That way there's no question because it's in your handwriting. But this is the problem. When police do it, when lawyers do it, when defendants do it, when you're preparing this affidavit, and then this witness gets cold feet and gets, I know, come on. A lot of people, the other thing I find is that a lot of witnesses naively believe that, oh, all I got to do is sign an affidavit. I don't have to testify. Oh, really? The affidavit is a precursor to testimony. You have to go into court and testify. And then they get scared or they want to back out. And a lot of that is pressure from the prosecutor. We've got prosecutors in I'm not going to say the case name, threatening to charge our witnesses with perjury if they testify. Isn't that something? So you got to be careful. Your homework has to be done when you're asking people to sign affidavits, and you got to be careful who you send to get that affidavit.
Reverend Tia, did you have a question?
Yeah, you know what? I was so intrigued every time Abdul speaks. I just get intrigued by how much information he has. And so I was looking at all of the ways that I think sometimes I forget that the polygraph is inadmissible in court. I forget that, as far as the polygraph and everything that comes with that insufficient ways is a waste of time. It's a waste of time for people, for the courts, for the system, for the taxpayers. And then if it is admissible, why don't we deal with the fact that if it's not admissible, why do we even have it?
Right.
There's so many insufficiencies with it as far as the test procedures, the confusion leading to the test, technical challenges, they say, questions of ambiguity. It talks about vague and poorly structured questions is constant. And then bias from whoever's giving the test, the examiner influence, the bias, inexperience, or incompetence of the examiner. All of these things play into what is going to be held as evidence, even though it's not admissible. Help me with that. That does not seem that seems like a bipolar statement in and of
Yeah,
itself.
it is. It's sort of paradoxical because they're pushing this. They're pushing the polygraphs on people, right? And there's for all the concerns we discussed that they're not reliable, and they'll swear up and down, oh, you don't have to worry, even though you failed it. We're not going to give it a lot of weight, but they're humans, right? And I got this polygraph that says you failed, and I'm the judge. I have the robe on. You think I'm going to put that out of my mind? Or if you pass, good. Everybody wants to use it then, right? But I don't like the idea of using them at all. Really, I don't. Even for employment background checks because of their unreliability. And again, it's based on the subjective test of the polygrapher. He reads these graphs. He reads these graphs that come off the machine, and he says, "Oh, I don't think he's being honest, or I think he is being truthful."
Right.
He's
And
basing
do
that.
and do your biases play into that? You know what I'm saying? Because the polygraph grapher, he knows the case. I'm sure he has some background of
They do.
it.
They do.
And then you're listening to this person. Have you formed an opinion, already while you're listening?
That is.
Um, to say that this person didn't pass it or not.
Yeah.
So all of that comes into play.
And polygraphs, there should be like classes on that because the public, and in their defense, they don't know better because they're not schooled at law, right? But a lot of
Mhm.
people, have come up to me and say, "Well, he failed the polygraph." And like that goes to show you the mind. People can't put that out of their mind, and I think judges
Right.
feel the same way. Defense lawyers, prosecutors, even though we in this profession know better because we know they're not reliable.
Right.
Hey, Hugo, welcome. What do you think?
I was just about to say, hey, Attorney Mac.
Look here, look here, look here. Just like them 10 virgins, some of them had the oil, some of them didn't. One of them 10 virgins said, look, y'all, split up that oil with us so we can get in. Them 10 virgins had oil said, no, you got to go back by your own oil. We ain't got enough to share. You know, hey, look here, we ain't had not no government cheese here. You got to go back and get your own. And so they went on back to try to get their own. By the time they came back, the party was over. Them doors was locked. So what I'm saying is, look here, I'm getting in this show before the door is locked. So y'all criticize Hugo Mack all they want, but before that door closed and the show ends, Hugo Mack gonna be here. So excuse me, I had the professional responsibilities I had to take care of. Some of the poor folk in Ipsy needed my help. I couldn't help it. I couldn't get in no sooner. It wasn't my fault. It wasn't my fault. So,
put your Hugo Mack cape on.
So, you know, it just wasn't my fault. But look, but I'm here now. But look here, on this whole issue, and first of all, God bless all y'all. And brother, good seeing you again, man. Good seeing you again.
Too,
you know, but see now, you got to understand something about polygraphs. It's not true polygraphs are inadmissible all around the way. That's not true. That's not true. In certain aspects, they are. I took part in a case or sat in on a case in Washington County Circuit Court where a man had been incarcerated for about 30 years for a murder he said he didn't commit. And they had some inmates that came, were saying, look, we signed an affidavit that back in the day, this guy couldn't have done it. And took a polygraph, took a polygraph. And the results of that polygraph were admissible. Okay, so you know it depends on the circumstance. And in the CSC statute, okay, everyone accused of a criminal sexual conduct, particularly first degree, has got a right to take a polygraph. Okay, so it's a nuanced argument. It's a nuanced argument because you know with the polygraph operators that I've had encounters with, a lot of them by the state police, by the way. State police polygraph operators, they say, look, you can't fool the machine, but you can fool the operator, which really makes perfect sense. Both ways, because the interpretation of that machine is up to human error.
Right.
It's up to human error. You see what I'm saying? And so, and really, there is one type of person that can defeat any polygraph. That's a sociopath. A sociopath, because they have no conscience. In other words, what makes a polygraph effective, when you ask a person a question, you know, were you at Bewick and Mac 12 o'clock, you know, on that night? It's based on your physiological reaction to a lie. That's what it's all about. So a sociopath that has no conscience can blank that out just as if you were asleep. That person's got excellent chance to beat a polygraph. So it's a two-way street. More, I can tell you from my career, my attitude towards my clients on polygraph was basically a negative one. Okay, a negative one, because more times than not, you are not going to pass the polygraph. You got, and I'm sure this might have been gone over before. You got to look at who's giving the polygraph. Well, if it's a state police officer, okay, you got to remember they're in the job of accusing people. You got to remember that. Okay. Now the police job is only supposed to be to gather information. Prosecuting a person is not a police function. That's a prosecutor's function. But the problem is when police are doing an investigation, their biases, their built-in biases and prejudice, okay, come into play. So yeah, they're investigating a murder, but they in their mind know who did it. So that means, you know what? We got our man or woman. We're not following these other leads, you know, and the true culprit could be walking the streets right now. And you got an innocent man or woman in the penitentiary because they never bothered to follow up the lead with the same aggression that they push the prosecutors for. So, you know, polygraphs can be a good thing. It's possible, but in my experience as a litigator, 90% of the time they've been used against people. 90% of the time.
So Attorney Matt just triggered something for me where he said once the police does their investigation and they already feel like they know who the person is.
Mhm.
And it just took me to the Samantha Wall case. So the other day I'm listening. I have been following it, but not following it. So I was listening on the news and they're talking to, I think, her ex-boyfriend who's testifying. And so he confessed to the murder. He confessed, he said he did it.
Mhm.
They go investigate him. He has a knife, he has his letter, like he has all this stuff in his residence saying that he did this murder, right? But somehow they said that he didn't do the murder. They let him go, right?
Mhm.
he And then they find this black guy who has no connection to this lady. The lady wasn't robbed. The lady wasn't sexually assaulted, but they connect him to this crime, and he's on the case. And I'm looking at the TV like, is this real? This guy is saying how he believed that he killed her, and now all of a sudden these drugs that he took and everything, and they said, well, he didn't kill her, he was high. And this is happening right now in real time, and I'm like, this is really unbelievable. And as I'm listening to the news people reporting it, they look like this is unbelievable. Their expressions as they're reporting is like, this is unbelievable. And I'm just like, I can't believe that this is happening today in 2024. You got a guy who confessed. He got all these reasons why he would kill this lady. And then you got a whole nother person on trial.
Well, yeah. 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 Wow.
But there's reasonable doubt all over that case. And I firmly believe, and I can't put my hand on it, but I believe that man is innocent. I believe that's a wrongful conviction that's happening right in front of us right now. I hope it won't take years before we get the new evidence. About the ex's confession, there's that creates some reasonable doubt, right? Because that creates some reasonable doubt. And whether the jury chooses to believe his reason for falsely confessing, hopefully it will carry the day where they'll be like, well, he still could have done it. And with Matt, I mean, you can tell me my understanding of confession type crimes. Police cannot charge you based solely on a confession. They have to have corroborating evidence because otherwise, if they charge you just on your confession, it's going to get tossed out of court.
Look,
corroborating evidence.
Yeah. Look. They've got people to this day confessing to the Hoffa disappearance.
Right.
Okay. So you have people that are serial confessors. Okay, who have a whole treasure chest full of mental issues. Okay, so I have not followed that case closely with this man, so y'all probably know a lot more detail about this man. However, as a person who ran for county prosecutor, I'm gonna tell you, if I'm the prosecutor and somebody confesses, that's not the be all to end all to me. Okay, because my investigation might lead to the fact or a conclusion this man couldn't have done it. He says he was there at the woman's house and he did this and that, but then we've got evidence this man was across town. I mean, or this man was somewhere else, or the evidence just doesn't add up to reasonable suspicion about it. Now, having said that, any criminal defense attorney with any stature is going to certainly raise that in front of the jury. Okay. Mm-hmm. They're certainly going to raise that in front of the jury because remember, a criminal defendant has got a right to raise alternative theories. So everything that the state says about a criminal defendant Well, you have motive, opportunity, means. So, well, so did John Smith.
Mm-hmm.
And plus, John Smith, through his own mouth, has confessed to this, ladies and gentlemen. Oh, well, ladies and gentlemen, yes, he did confess, but it's not plausible, this and that. Well, plausibility is a matter for the jury to decide, not the prosecutor.
Mm-hmm.
Okay? And remember, all you have to have is reasonable doubt. You know, could the boyfriend have done it? Could he have done it?
Could have.
Yeah. Can we say that he could not have done it? Because if the jury says, you know what, we can't say that the boyfriend could not have done it, there's a name for that. It's called reasonable doubt.
Mm-hmm.
And the other thing a good attorney would argue, Hugo, is that the only reason why the police don't have corroborating evidence is that the ex-boyfriend was smart enough to get rid of it.
Mm-hmm.
I think they did find some blood in the car. They tested it and they said it wasn't human blood. It was the blood of a dog. And that probably is true. But the defendant doesn't have to prove burden, right? The prosecutor doesn't have to prove motive. Motive is good if they have it.
Mm-hmm.
Prosecutor doesn't have to prove premeditation and deliberation.
Yeah.
And the defendant doesn't have to prove anything. But you can like Hugo was saying, how a good lawyer would argue that you definitely want to keep that in front of that jury. Look, this man confessed, and then the prosecutor's going to say, well, there's no physical evidence that corroborates his confession. There doesn't have to be. He was smart enough to get rid of it. You think he's going to keep the bloody knife around?
Right. And what the good brother is saying is true, because what I remind juries all the time of, reasonable doubt doesn't only occur from what you see. Reasonable doubt can occur from what you don't see.
Mm-hmm.
What you don't see. Okay. So what the good brother said is right. So, well, there's no corroborating evidence. Circumstantial evidence has put many a man and woman into prison. Okay.
Exactly.
But you got to understand, the smart defense attorney is going to make circumstantial evidence work in the client's favor. Said, well, we don't have any human blood. You don't need human blood to convict somebody. Other circumstances can do it. So if other circumstances absent human blood can convict somebody, why can't other circumstances absent human blood acquit somebody?
Right.
And his attorney is also doing a good job of raising reasonable doubt by arguing that was more of a crime of passion. She was stabbed 8 times.
Yeah.
That wasn't someone who just hit a lick and got out of there.
That's true.
And also, there was no evidence that anything was stolen, which defeats the prosecutor's theory that this was a robbery turned murder.
Yeah. No. I agree firmly with what Abdul said, because that is passion. That's rage, is what that is. Mm-hmm. Okay, that's rage. And just like I've had cases where somebody has been killed and stabbed repeatedly, like in the groin area. Okay, in the groin. See, that's a personal thing right there. Is what
Mm-hmm.
that is. Okay,
the location of wounds. Yes,
and so that's a personal thing, and what y'all have been saying is true. The B&E man, the rob 'em sticking up man, it's not personal. It's just like Nino Brown said in New Jack City, it's never personal, always business. Okay.
And the time it took for that to happen, that it doesn't fit the prosecutor's theory that he did this and got out of there. She had bruises. There was blood in several rooms of the house. There was this long struggle.
It was a fight. Yeah.
And more importantly, when they found his jacket, which there was blood. Her blood is on the cuff of his coat. And the defendant. I don't know about this, Hugo. What do you think? But I don't think his attorney should have tipped his hand, because he's at least making some admission that his attorney's theory is, well, and his theory makes sense, because when you reach down, right, his attorney's theory is that he stumbled on the body and he reached down to see what I know a lot of people, if you see a body on the ground, they probably will get curious and move it to see if it's alive, and that's how you got the blood on there. But it's so microscopic.
Yeah.
In blood.
Yeah,
Right.
but well, okay, but y'all listen to me, okay? Listen to me, okay? I'm sorry. I will buy everybody on this panel a chicken dinner at the Kentucky Fried Chicken of your choice, including fries, large drink, and a dessert, if this man is not convicted. Okay? I'm sorry. I'm sorry.
Oh, I know.
Because at the end of the day, one piece of forensic evidence outweighs any kind of theory about it could have been somebody else, it could have been this and that, especially when the person says, I was there, but I got there after the fact. Okay.
Well, he didn't make any statements or confession.
Yeah, well, okay, but what I'm saying is, if he doesn't get on the witness, I mean, if he doesn't get a witness stand and says, look, I admit that I was in the neighborhood, but I saw this body and I just went to, I leaned over it and I touched it. I'm telling you, man, that is something straight out of a Charlie Chan movie. Okay. And so what I'm telling you is that, like I said, a dinner at the KFC of your choice with large fries, a drink, and a dessert of your choice. You can get you some of them. You can get you some of the macadamias. You can get you some of them apple pies, whatever that is. Some of that lava cake. I'll pay for the whole damn thing.
I think it's going to be a hung jury.
Well, okay. Now, remember, you only need one for a hung jury.
You need one.
Okay, but what I'm saying is, let's just say there is that one. Okay, that says, well, I'm not convinced. You know what the refrain to that one juror is going to be? How you explain that blood on his coat?
Hey,
microscopic.
But also, the prosecutor has a problem that for this overkill stabbing, he should have more blood than he should have been. The coat should have been.
He should have been drenched in blood because it was a blood bath.
Okay.
Do that.
Yeah.
One juror could believe there's an innocent explanation for that microscopic on that coat.
Okay, y'all. Okay.
Then they took. I'm just gonna say.
Okay.
Didn't they take his coat in as evidence?
They took the coat in, but and they even said you can't even see the blood with the naked eye.
Okay. I love y'all. J Love. Start picking out your restaurant. Tia, get on Google, find you a KFC where you live. Abdullah, wherever you are in the city, find you your KFC. And all y'all got to do is let me know the date and time, and I'll meet y'all there. Is that fair?
You know what?
I want to go. I want to go to the restaurant out there in Washington on
copies. You want to?
Yeah, me too.
I see. You want some upgrade on your
soul food. Yeah.
Okay. Hey, Abdullah, you outvoted. Come to copies. I'm going to buy you dinner too.
I want some andiamos. I'm going to go up.
Okay, hey, brother. We love all peoples, man. We love all peoples. We go there, brother.
I love some Italian. But and you know what? Sadly, he may very well be convicted. I've seen juries. I don't know how juries convicted Roosevelt Pettiford. Jurors, I'm gonna tell you, it's been my experience. This is why a lot of people, I always tell people, it's juries. I mean, I'm okay. Jurors, I don't want to say they tend to convict faster than judges, but they don't follow the facts. No. They don't follow the law. They don't follow the instructions about reasonable doubt. Because in that case, there's a lot of reasonable doubt. Forget the blood on the cuff. This man should be drenched. But jurors do convict. I know people get convicted, and I'm like, what the hell was that jury thinking? There was reasonable doubt all over the case. The other problem is, I was telling somebody the other day about cell phone technology and all this cell phone tower technology, and they brought some of that in to prove that he was in the area. Well, that's not criminal. That was,
no.
You could be driving through that area.
And the problem with that is, here's this young black man who was walking in the area.
We shall overcome. Okay, y'all keep saying that. Abdullah, I love you, brother. You know what? I'm going to tell you like they told the man that was wrongfully convicted and sentenced to the guillotine. when he getting ready to go up there, the hangman, the guilty man saying, well, keep on saying you innocent. That's good. That's good. That's good. Now, step on up now. But keep on saying it. That's good. That's good. Abdullah, I love you, brother. Keep on saying that. J Love, I love you. T, I love you too. Cuppies and andiamos. That's what we go.
Yeah, I mean, I just think that once they set their sights on him,
Yeah.
Okay.
They went full force.
Yes.
When they got a person, because at the time that this murder happened, right? We got all this stuff going on with Israel and all this stuff going on, you know, it made like national news because of her, you know, her race, right?
I think there was an urgency to make an arrest because she was a high-profile figure.
Yes.
You know,
she had a connection with the attorney general.
Okay. Who is also
their
Jewish,
friends.
who's
Yes.
also Jewish. Okay.
Who also made statements when he was arrested. And I thought to myself, as the highest law enforcement officer in the state, shame on you.
I agree.
She made a statement about.
I agree.
She hinted that he was already guilty. This was a Dana Nussel saying. I wish when she said it, I was like, oh my God.
Agree. I agree. Grossly inappropriate. Grossly.
Totally violated the presumption of innocence.
Yeah. But I'm harking back. And by the way, I told y'all he wasn't going to take the witness stand. I told you that.
Oh, I don't think he better not take the witness stand.
No. I'm talking about some weeks ago in New York. In New York. Yeah. Remember all that bullshit talk about I'm gonna get up there, I'm gonna tell what. I'm sorry, y'all. I have to say this. I'm sorry.
Oh, I thought he was gonna take it.
Yeah, I know. Brother, I love you, man, but I should have made you get me a dinner on that one. I told you I wasn't gonna take no stand.
I told you a dinner, don't I? I do remember that bet.
So
crazy, and he ain't that crazy.
Yeah,
he was so arrogant that he thought he was above everybody. He'll do this.
No. I know. But remember, he was doing all that talk about he's going to expose him. He's going to tell him what happened. I said, punk, you ain't going to bust a grape in a wine factory. So what so all I'm saying is this: the only way record this, J Love. You're recording anyway. The only way that man is going to have a chance of an acquittal is to give that jury, and I'm not saying it's right, is to give that jury a reason not to convict him. Okay? Because what I'm saying is, we can have all the theories about, well, he ought to be drenched in blood, he ought to this and that. Okay, that's a nice theory. But the bottom line is, unless you can refute that blood, I don't care if it's microscopic or not, on that man's jacket, how did that woman's blood get on that man's jacket? The only person that can try to refute that is him. Unless you're going to say his jacket was stolen and mysteriously turned up again. You know, he reported a stolen jacket and all of a sudden he found that at his doorstep. That's not going to happen, because I'm telling you, what that prosecutor is going to do, because I wanted to be chief prosecutor, she is going to focus in on, ladies and gentlemen, the attorneys can argue back and forth and people can banter like a ping pong back and forth. But one piece of hard evidence, scientific evidence, that's a hell of a mountain to climb. How did the blood get there? Now, the man doesn't have to say anything. He doesn't have to say anything, okay?
Innocent explanation for it, too. I can see where there can be innocent explanation for it.
Okay, yeah. So somebody's got to put it forth, though, Abdul. Somebody got to put it forth, okay?
And I'm just going to say this. Didn't they find a microscopic piece of blood on Devontae Sanford's shoe? Like,
they sure did.
Way later on, after he was exonerated.
They sure did. And it was just a few years ago. They raised the specter that, oh, here comes charges again. They found that blood after he was exonerated, and nothing ever came of that. But it was, but but here's the thing: why didn't you find it in 2006 when it was not right there?
Right.
This was like 10 years after the murder. They claimed you're right. They claimed they found blood on the shoe. See, here's the thing I don't like: when police have this autonomy over this DNA evidence, because we didn't just find out from the O.J. Simpson case how dirty they will plant it on you, And I would go so far to say I believe they could have done it in this Michael Bolano's case. Stupidly, but police are stupid. You know, they know they have to have a physical connection. So let's put this little bit of blood on his sleeve. But a smart officer would have drenched it, but okay, they did. But it is possible for police to do that. And not just possible, they do that.
Look,
What got on Devontae's shoes, because you know what they did at the crime scene? Just like with Mr. Jackson Bolanos, once they focused their attention on Devontae, because he was an innocent 14-year-old kid, I'll tell you what he did. He walked up to the murder scene. He saw all these flashing police lights from his window at home.
Yeah.
Walked down there, a curious onlooker, and look what happened to him. They will do that. And I firmly believe that's what they did that to this Michael Jackson Bolanos. The prosecutors putting all these cameras around there showing him in the area. They don't have any evidence he was in the house, though. And I think, and that concerns me, because there's a court rule that says scene of the crime alone is not evidence of guilt, but this is what's happening. I mean, I understand that it's relevant for purposes of putting him in the area, but there can be an innocent explanation for this.
Well, right. And
I'll tell you how that blood got on Devontae's shoes. They walked him. Look at what they did. This is how they got him to sign that crime scene sketch. That was accurate, but a police officer drew it. They walked him in the house while the bodies were there. They let him contaminate the scene. That's how the blood got on the bottom of his shoes. Detroit police did this. They knew what they were doing when they walked him in that house.
Yeah. And right. And that's a very plausible explanation. Okay. But I don't see that in this case. Okay.
Well, you have to prove it too. You do have to prove that.
Yeah. You see. Yeah. So I don't.
About to say allegedly.
And the jury may not take to that. So you got to be careful.
Yeah.
They may not take to that. I think an innocent explanation is better than saying, well, the police planted it. Well, that sounds good, but okay, the prosecutor has to prove guilt beyond a reasonable doubt. For you to make that allegation, you better come with some proof. It's just
right.
It's
exactly.
I don't know. It's a tricky. It's a risk. But
it's going to be interesting to see how the outcome of this is going to be.
Okay. But see, remember now. You're talking to a man here who had a full prosecutorial mode during the campaign. Okay. And what I'm saying is that what I know from jury selection over the few decades I've been fortunate to be in this job, jurors tend to be nothing more than on-site tapings of the Oprah show. Okay, I'm gonna say it again. On-site tapings of the Oprah show. You remember Oprah? Everybody got an opinion. Everybody got something to say in the audience. You know, Maury Povich. You know, Ricky Lake. All that stuff. Karamo. All that stuff. It's an on-site taping of those type of shows, because the bottom line is, regardless of what those jurors say in terms of following the law and being impartial, none of them is going to leave their bias and prejudice outside that jury room. No. I mean, we say it. It sounds good, but the truth of the matter is, all that stuff, if they got a Trump sticker on their bumper sticker in their car when they pull up to that parking lot, that stuff is going right with them into that jury room. Yes, if they got a Cornell West, whatever bumper sticker on their car, that is going with them into that jury room. And the challenge I have as a litigator is to confront them people and let them know two things. One, any one of you here is not indispensable. I've got the authority to remove any one or group of you, actually, as I see fit, which is true. Right. Okay. It's called a peremptory challenge. Okay? Yep. You see? So I let them know that. And two, I let them know, hey, look, when closing argument comes, I challenge them, and I'm not trying to tell another lawyer how to do it, but I challenge them, and I talk specifically to that group of jurors that shouldn't be on there. So what are you talking about? I challenge a group of jurors who know good and damn well they're not answering them questions honestly when I was asking them questions before they got on the jury. I challenge them. who did not want to say how prejudiced they was, how biased they was. And I challenged them. I said, you know what? It's not too late. It's never too late for redemption. When you go in that jury room, you have to challenge them. The bias and prejudice that you brought in here to this courtroom, you said would not be with you, and you know good and damn well has been with you throughout this whole trial. It's not too late. It's not too late. Shut that BS down, okay, and get in there and do your job. And see, the only way this young man is going to be acquitted is if whoever that defense attorney is ask them, that juror, to enforce the moral imperative. And the moral imperative is, I have to believe this man is guilty as assuredly as I know my own name, because that's what I tell jurors all the time. To believe something beyond a reasonable doubt means you know it as well as you know your own name. If I ask Tia what her name is, I ask Abdul what his name is, I ask our host, Janice Green, what her name is, and I ask, well, I'm not going to ask me what my name is because I've been known to be deceptive. But anyway, the three out of four ain't bad. 3 out of 4.
Somebody probably saying, "Who is Janice Green?" Go ahead.
Okay, so that is the only way, because Brother Abdul speaks the truth. The blood stain is damning evidence. The damning evidence, because it isn't a matter of lying. Okay, it's not a matter of lying. But there seems to be reasonable doubt. Like J. Love said, if this man did this, how come there's only a microscopic amount of blood? Wouldn't his whole coat be covered with blood 18 times? You know, blood splatters. It splatters, you know. And what is the motive for this man doing this? Most people, if they trying to just rob somebody and it's a bunch of confusion fighting all throughout the house, they're going to say, to hell with this. I'm out of here. You know? I'm out of here. I'm out of here.
They ain't gonna stab you 8 times to take nothing.
And nothing. So, I mean, the average career criminal, they're not looking for smoke. They want to get in and out. Okay.
In and out.
But you know what I find? Jurors tend to convict so fast, and they tend to put undue weight on one piece of evidence, like Hugo was saying. This blood on the sleeve, it's a problem. It is. But if your job as a defense attorney is to give is to convince them that there's reasonable doubt for all this innocent reason that is on there. But jurors don't. They put undue weight on that. Well, he must have did it because otherwise there would be no blood on his jacket. Well, common sense, and judges give common sense instructions to juries too. Mm-hmm. Common sense will tell you it should be drenched. I mean, it should be drenched with blood, but jurors don't. I'm gonna tell you, I think sometimes some capital cases are better for a bench trial. This would have been a good case for a bench trial. I don't know much about this judge, Van Houten. Some judges, I wouldn't let them try me on a ticket. Margaret Van Houten. Margaret Van Houten.
Oh my God.
I don't know, her leanings, whether she's, middle or to the middle or far to the right or left. But
no, she's horrible. That was the same judge that Gerard had.
Oh, really?
Yes.
Wow.
Yes.
Yeah. Okay, but y'all remember, the prosecutor, thanks to John Engler and his crew, the prosecutors got to agree to a bench trial. You got to understand that, they've got to agree. Once upon a time, it was only the defendant's prerogative to say a bench trial or a jury trial. The prosecutor has got to agree to that. Just like a preliminary examination. A lot of times my client would go in, it's not advantageous to have a preliminary examination. So say, look, we'll waive prelim because I don't want all that testimony preserved. Okay. I don't want all that testimony preserved. And the judge always asks, does the state object to the preliminary examination being waived? No, judge. So you got to understand, if the prosecutor's office knows you've got like a liberal, more acquittal-oriented judge,
they're going to push for a jury.
They'll push for a jury.
Yeah, and this is my other thing, you guys. People want to get back home. They don't want to be involved.
That's true.
It's a couple of days too long.
Right.
They're going to go in and come back because they got to get back to life.
That's right.
And they don't understand that somebody's life is on the line.
That's
They're
true.
not thinking about whose life is on the line. They're thinking about, I done missed 2 days of work, and what they get, $15 or whatever,
That's true. That's true.
and I got bills to pay.
That's right. That's right.
And so those things come in play too. And
That's right.
and we have more empathy and compassion for people, even for the victim. They deserve justice. That person deserves justice.
True.
But if you just say, well, he look innocent. He looks guilty. He got some little blood on him. So how would he, if you take that kind of um um behavior in the courtroom, and you just thinking about yourself and whatever, that's why a lot of people are in Michigan Department of Corrections right now.
That's true. That's
The
true.
juries got it wrong in a lot of cases.
Absolutely.
Yeah.
People knows. This is why I fear the jury. Not fear. I don't have respect for the jury system because of this. Because this guy, if he's convicted, I will be even more disrespectful to the jury system, because they don't pay attention to the reasonable doubt instruction, obviously, but also a lot of people don't know this. Jury convictions are tougher to reverse on appeal than a bench.
Yeah. So
convictions, you can convince the appeals court, look, the jury got it wrong, and I know the Court of Appeals say, yeah, we agree with you, but the conviction stands. Jurors are allowed to get it wrong.
Yeah. And see, you also have to remember, everybody, our Supreme Court has said, and I tell people this all the time, particularly young lawyers, our Supreme Court has said it is all right to kill an actually innocent person as long as they've had a fair trial.
Yes.
Right.
Yeah.
And that's all that's all that matters.
Justice
It doesn't matter if you're innocent.
Okay. J Love, you, me, and Tia could get together to conspire against Abdul, conspire against this man, okay? Accuse this man and set up a set of circumstances where the man didn't do a damn thing wrong. But we will conspire against that man and say, look, I saw him kick that window in. Yes, he did. Yes, he did. We can conspire against that man. All three of us risk perjury on the witness stand and convince a jury why that man kicked that window in like that. And so that man ain't done nothing. He ain't done nothing. But and get this man convicted, give this man a felony record, ruin this man's career, send this man to the penitentiary, make this man serve a sentence, make him come out and still serve a sentence because he got a felony on his record, make the man go on welfare or worse, lose his family, lose his friends, lose his self-esteem, maybe resort to street crime, maybe resort to drugs and alcoholism, because we conspired on that man, and the system will say, that's just too bad, Abdul. Sometimes it sucks to be you.
Yeah.
And that's true.
Right. And you know what?
It's true with jury
It
convictions.
happens. That happened recently in Rochester when the guy who did the mass shooting out there, and the Rochester police, because a group of people said that they saw this black man with dreadlocks. Okay. And that it was him. They said it was him. They saw him. This young man was 16 years old with dread, had stepped away from the party. They were having a graduation open house, and he went to go get some ice cream, not knowing what was going on. Those people said, here he is getting ice cream. He got the ice cream. They said it was him. They said it was him at first. He ran home, dropped his ice cream, went back home. They searched the house. They wouldn't let anybody who was at the party leave. And then time passed, and they find that the guy who did it did a self-inflicted wound to himself.
Wow.
Look at the rush to judgment, people.
That young
Right,
man
but then
was
they're not
on his
broadcasting
way.
that. I haven't heard that
No,
one
they're not
time on the
saying.
news. They're talking
They're
about
not
how
saying
fast
nothing.
they was alerted because they got this new real-time 911 system, and they was there in minutes, and they was that's all they've been
No.
bragging about since this
Yeah, they
that
have
splash
real-time
smash thing
vigilante.
happened.
That's what they had.
Mm-hmm.
Yeah.
They
But
had real-time vigilante.
before we get
Yeah.
off, Miss Abdul, we wanted to talk about Shamar Avery. Shamar Avery was on here a couple of times, not last year, but the year before, and we discussed his wrongful conviction. You had an update on him.
Yeah, he filed his WICA claim for compensation. His conviction was vacated on new evidence, and the claim was denied at the Court of Claims. He appealed to the Court of Appeals. The Court of Appeals reversed it. He went to the Michigan Supreme Court. The Michigan Supreme, the Court of Appeals upheld the Court of Claims decision to deny him compensation. And then he went to the Michigan Supreme Court. It upheld that decision. So the result is he's not going to be able to be compensated for any of those years he spent in prison. But here's what's significant about that case. Most of these WICA claims, they call them WICA, the Wrongful Imprisonment Compensation Act claims, when your conviction is vacated based on new evidence of innocence or that you were not involved in the crime, you are entitled to sue the state for every one of those years you were in prison. In theory, the theory is the new evidence has to show you're innocent or you weren't involved. That's how the statute is written. So harken back to what I've always said about these convictions that are dismissed without prejudice, but there's not a declaration of innocence. Mr. Avery took his appeals up to the Supreme Court, and what happened at the Court of Claims, the judge at the Court of Claims held a trial on his WICA claim. It was the first WICA claim that went to trial at the Court of Claims. All the claims before that, they were settled or dismissed. This case is going to embolden the Attorney General's office to settle less of these claims and now fight them on these dismissals without prejudice. When these types of when the defendants in this class sue for compensation now, here's what happened. At this trial, his attorney argued that the Court of Claims judge was only required to consider the new evidence of his innocence. And the Court of Claims judge said, I have to balance that new evidence against the evidence that was used to convict him, because he was never declared innocent. He did that. He balanced all of that old evidence that came in at his trial. It was some statement of some witness who still said he did it against this new evidence. And the Court of Claims judge concluded he was not innocent. And therefore he was not entitled to compensation. The claims went through the appeals, and Mr. Avery argued that the court was wrong for holding a trial to determine his innocence when his conviction was vacated, and the court was wrong, number two, for considering the record evidence that came in at trial against the new evidence. The Court of Appeals said no, because that's what the statute says must be shown, that you're innocent or weren't involved in the crime. Your conviction was dismissed without prejudice, but there was never a declaration of innocence with the prosecutor, a judge, or a jury. You were never retried, in other words. Your conviction was vacated without prejudice. That's not a declaration of innocence, which is what I've been saying for a long time. But this is the first WICA claim where the defendant lost. And now his appeals are over. He can't go to federal appeals because WICA is an interpretation of a state statute. And the highest court has already spoke on that. The Michigan Supreme Court did not issue an opinion on it, but they upheld the Court of Claims and the Court of Appeals after oral argument. I think I sent you the video of the oral argument, Jay. If I didn't, I will. And the Michigan Supreme Court's decision. They said they were not persuaded that the questions presented should be reviewed by the court.
Right. And in that paragraph, they can essentially dismiss a person's life in a paragraph. Okay, in a paragraph. I'm well familiar with that paragraph. Okay, well familiar with it, and which is why I'm gonna say this. J Love, it's good to talk about exonerees and have people come on and stuff, but I don't add to anybody's load that's been through a war already. But really, the truth of the matter is that's a misnomer. Okay, this term exonerees is a misnomer. The only exoneree is like the Dr. Richard Kimball's of the world. Okay, where somebody else is shown to have done it, where it's shown. I was in Kansas City, Missouri. I can't be in two places at the same time. Okay, this thing about a case being reversed, let's say on an evidentiary matter, and the state deciding not to recharge, that is not an exoneration.
Not an exoneration.
It is not. So that's why, like when I appear in these different programs and they talk about, well, these are the group of exonerees, I don't say much. Like I'm not here. I'm not here to make anybody hurt more when they've been hurt, obviously, already. Okay. Any person who does not receive a fair trial, you've been hurt. You've been hurt. Okay. Psychologically, emotionally, financially, you've been hurt. So, J Love, when I look at programs like ours, we have a multi-function. Okay. One, the greatest function we do, we keep the narrative going. We keep it going, and I got much respect for all y'all, all three of y'all, because you fighting a hell of a fight in your venues. Yeah, you are. So yeah, I feel for the young man. I'm gonna end it with this. If the man didn't kill that woman, I feel terrible, but I wasn't there. Okay, so I don't know personally. I can just analyze it as a litigator. But Capis non diamos, brothers, sisters. Okay, so
I just want to say, the exoneration or being exonerated, that's a feel-good word, right?
It is.
It makes it's a feel-good word, and it brings attention like somebody really did something awesome, right? But are you really doing something awesome when you truly haven't exonerated a person? They're still walking around with that letter on their back, at any time if somebody says a witness shows up or something happens that could turn your case around.
Or a prosecutor is elected. A new prosecutor is elected. Remember the prosecutor in Pennsylvania. He ran on one issue alone. You elect me, I will prosecute Bill Cosby. Remember?
Yeah.
Okay. So yeah, you're right, J Love. Kim Worthy's not going to be there forever.
No.
Okay.
And nothing stops her predecessor from reviewing these cases all over and saying, "Hey, I don't think we should have been free."
Absolutely. So I'm sorry, but I just had to say that. You are so right, J Love. You are so right.
And what's interesting?
So we have to. I'm sorry, Mr. Abdul. I just want to say this one thing. We had to not get caught up in the feel good and really operate on the real. Because the feel good only feel good while it's in season and while it's
That's right.
It's the trend right now.
That's right.
But these trends, and I want to talk about this next month when we talking about Project 2025. Some of this stuff is going to end.
That's right.
It ain't gonna feel so good. So we have to start feeling.
That's right.
In the real.
Right. That's right.
Okay, go ahead, Mr. Abdul. Sorry.
Ain't nothing wrong with feeling good. You got to have some help.
Yeah.
But Avery's case was interesting. It came out of Wayne County through the Conviction Integrity Unit, where all these convictions were vacated without prejudice, and it ultimately was a sword against him, because at the Court of Claims, the Attorney General's office argued artfully He was not exonerated. This was a dismissal without prejudice. In fact, the prosecutor specifically said it was not an exoneration. So we're entitled to hold a trial up here before we pay him. You're entitled, judge, to decide if he's innocent. This is what, and the Court of Claims judge, I think it was Christopher Murray, said, you're right. I'm going to hold I want to hold a trial, and I want to look at all of this evidence review, not just the new evidence. And
yeah.
And they raised that at the Court of Claims. The Attorney General's office raised that what Kim Worthy's did. So what that tells you is the case is coming behind him now. It's going to embolden the Attorney General to fight them more instead of settling these cases, because they're going to look at these. Well, here's another one. She dismissed without prejudice. So you wonder, did she know what she was doing when she was doing this? Probably so. I'm sure she read the statute. But neither here nor there. I just wish, I'm for exoneration. So otherwise, that's why I do this work.
Right.
Because I believe.
We want people to be exonerated. We do. But we want them to be exonerated, right? And not just released. Because if I remember it correctly, Shamar case was before the integrity unit was even formed. So, and so before all of this new stuff was happening, he was released, earlier in the game. And I think, he didn't have a lot of details about why he was being released. So we had to go back and really listen to his story. I don't think he had like a lot of details. He just, hey, you're being released, So I'm just saying, we have to really like deal in the real out here and hold people accountable. Like, if these people are not doing what needs to be done, why are we still voting for them? Why are we still blindly voting for these judges? Why are we still blindly voting? Oh, okay, Kim Worthy, I'm just going to vote for her because she's been there 20, 30 years. Sometimes we got to stop. We're our own worst enemy because we're doing things that we shouldn't even be doing anymore. And history has constantly shown us that, all this blind voting and all this, name recognition stuff has always worked against us. So we got another election coming up in August and November. And people, we as citizens, as the bosses, because our tax money pays these salaries.
That's true.
So we're the boss. And we got to start acting like we're bosses. Like, we really got to start like, okay, let's do a review. Most jobs does monthly reviews or yearly reviews or whatever. We need to start reviewing and really sitting down with looking over this stuff and saying, hey, I don't know about this person. Let me look them up. We have all these things, this technology at our fingertips that we could be using for the good. But we use it for, gossip and crazy stuff and celebrity stuff and all this other stuff. And just like you said earlier in the show, Mr. Hakeem, when you was talking about how we should have been so upset about this 14-year-old kid, we're all over the place. And when stuff like this happens, like the 14-year-old kid that was innocent that went to prison, like the 16-year-old Reverend Tia just spoke on, that was harassed and the whole family terrorized as he as a shooter would go get ice cream after he done shot up a splash pad. We had to start doing our due diligence. Like, that's that kid, but that could be your kid or your relative or your loved one or whatever. We have to start thinking beyond our little selves and think about this is more to life than just you. All of this stuff affects you, whether you know it or not. And when you get permission, when your silence give people permission to do whatever they want, they're going to do whatever they want.
Whatever they want.
And they're going to run up through your house and scare your kids and your wife. Talking about you shot up a splash pad, you just had an ice cream. What the hell? I'll sound like that right there. But really,
and because You know, the funny thing is we will go on and review anything, review a restaurant, anywhere we went, review the food, you know, all that. We have to review our judges, the
Mm-hmm.
prosecuting attorneys. We have to start reviewing people and put it out there and let people know they're the worst or they're the best. I see that
And it,
they have a perspective that is filled with justice. They want to do the right thing.
mm-hmm.
And if they don't care about people, you got to write that. Give them a 0. We need to find ways to really, I mean, and I'm going to start looking, is it possible to judge the judge?
Right. And then also, when you even like with this presidential election, you got to look at who you put in these places as mayor, as governor, as president. They control
Mhm.
some of these seats that don't get voted on. You know, uh, I was reading about if Trump gets in, it's a possibility that he can put in 2 more Supreme Court justices
They're going to be
in
conservative.
place. Oh, you think you're in trouble now? I'm just saying, we
It's,
gotta like
yeah,
think beyond, just Trump. What else it is? We got 33 seats in the House that we need to be looking at. We have all this stuff that's in front of us that we need to be focusing on and focusing on this craziness and come on, people. We gotta do our work. Or, just don't do nothing and see what happens.
it's a sad day in America when a criminal can run for president of the United States, but a clerk couldn't keep his job at the Michigan Supreme Court
Mm.
because of his past conviction. Now,
Wow.
I know what I said earlier, and I still stand by that. But comparing the two, he should be running. He should not be eligible for presidency either.
Right.
He's gonna. We're a laughing stock all over the world. They're about to elect a criminal in the White House.
With not one felon, not
No,
one.
a repeat
You got
felon.
34.
And this is the man who advocated for the execution of the Central Park Five, who were really innocent,
Exactly.
and he wants everybody to believe he's innocent.
Right.
I
Not one. He doesn't get. He didn't get. He didn't get convicted of one felon. You guys.
Oh, it was a lot of
All counts. He was convicted, and he's walking around here. He's gonna be doing a debate. What, next week or the week after?
Yeah.
He's free to go from state to state. And I never seen anything like most people. When you
Mm-mm.
be remanded over
and
until
here people
sentencing.
who are truly reformed, innocent or not, have to they have a dilemma. Do I answer that question truthfully on my application or not? Because they might not give me a chance. Yeah, that's a bad feeling.
Yeah.
Mm. Yeah, he's gonna be able to debate. He can debate, and he's debating not behind bars. This is the laughing. United States is the laughing stock with ignorance at
Oh
its lead.
yeah, they think we're everything's it's not a democracy. It's like
Right. It shows
yeah.
really what we've been saying since we've been over here on this platform.
Mhm.
There's 2 different justice systems.
Oh
You
yeah,
know,
laws.
he's walking around here like, look, black. I'm like the blacks.
Yeah,
Look at me.
yeah.
And I'm like, don't get fooled by
Oh,
that because he is not like you.
no.
No.
Oh,
But
yeah.
anyway, guys, this has been a great conversation. Thank you, Mr. Abdul. You
It's,
always
Yeah.
it's good to see
bring
you again. Thank
a great conversation and bringing awareness of wrongful convictions that we're not even privy to, that we haven't heard
Mhm.
about. That's flying under the radar. And I hope that these people that Paul Clark, Ricky Rimmer, and Mr. Pettiford, get their opportunity for justice and their families, because it's not only stressing and traumatic for the people that's incarcerated, it's also for the families you know, that had to be 20 years, 30 years, 50 years, you know, of their loved one being wrongfully convicted. And also for the original victim who, you know, thought all these years that the person that went to prison for the crime was the person, and then to find out, you know, you done put an innocent person in prison. That's traumatic as well. So I just want to thank you guys, because this is brings a lot of information out, and hopefully people share this again, share this information on your platforms. And
thank you for giving
hopefully,
us to educate
yeah,
about this, because you can't get this with the mainstream media, and we know there's political reasons for that. Right now, the theme is to praise, to give glory, and to, you know, we can't get. It's unfortunate. It's not a real free press either. You're the free press, Jay. You're the free press. You know, you let us all get on here and vent and to, but at least to educate people. That's what you hope to do.
Yeah.
right, right. And guess what, you guys? If you get into, you know, some issue, you got the Freedom Line. You got we got
Hugo
Mr.
line.
Abdul 30 back on the Freedom Line. And you got Mr. Abdul, you know, you got Miss Diane, and Travis was on last week.
Diane is a real trooper. She way back. Well, we were with the socialist. I was with the. I think she was with the Socialist Worker Party. If you're watching Diane, and I'm mistaken, I apologize. But I'm. She's been a trooper on all social justice issues. A true fighter. She's a real angel.
Yes, and these people that's here, you know, this is hard work. And so that's why I always like to, especially for Miss Diane, to promote her. She does this work. She's not getting paid for it. And, you know, we have to support these platforms that she's a constant in the community. So we want to support her and her platform. You know, no amount is too little and too large. Keep her website up so we can keep these wrongful conviction stories relevant and out here. Attorney Matt, Mr. Abdul, do you have anything else to add before we leave tonight?
No, I don't have anything else to add. I'm just, you know, we keep the fight alive, and unity is important. It takes all of us, and you know, we just keep educating and informing people. They need to know what's going on.
Right. Yeah. And Rabbitier, do you have something?
Oh no, I'm good. The only thing I would always add is that, you know, like Abdul was saying, we gotta stick together, keep doing the work, and get ready for cuppies, because I'm gonna pray.
You know what? I'm glad you said that, Tia. I'm glad, and I want you to listen especially, because I ain't never been to Andiamo's, but if I go, you finna buy my dinner. So
I owe you one, because I thought Trump was going to testify.
Yeah. See, you was wrong then, brother. I love you, but you was wrong. So look here. So J Love, okay, I'm sorry, Reverend Tia, but remember, cuppies, there's another side to this coin. This ain't no heads I win, tails you lose thing. Okay. There's another side of this coin. When that man is convicted, when we go to cuppies, J Love, you gonna buy me a dinner? And Reverend Tia, you're going to buy me a dinner, but I'm going to take your dinner out with me to carry out. I'm eating there. Okay. Abdullah, when we go to Andiamo's, I'm not going to insult you. I'm going to eat my dinner there. Okay.
You know, I'm just right down the street from the courthouse, so I have to make a stop there first and raise some noise. I'm going to have to fight for the brother first.
I know that's right. I
might get arrested for some.
Okay. Hey, but J Love, you know, when it comes my turn, what I got to say will only take 34 seconds, because I'm gonna quote my good friend Whoopi Goldberg. So you let me know when it's my turn. My statement is only
right now. It's your turn right now, Attorney Matt.
To quote my good friend Whoopi Goldberg, guilty, 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 guilty. guilty, 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 guilty,
Say it
guilty.
that many times.
I don't think she was that bad.
Hey,
Maybe
hey,
he
look,
was doing that
look
for
here.
Trump on the 34 accounts.
she said, I love y'all people on The View, that little show she on, but let me make my statement to you. It's only going to take 34 seconds. So, J Love.
And I want to say, you guys, in closing, in honor of Juneteenth, none of us are free until we all are free.
That's true. That's true.
So
That's true.
we'll see you next week, you guys.
right.
Thank you, everyone.
Thank you.
All
All
right.
right. Hey, God bless y'all. We love you now.
Love you too. Take care. See you, Tia.
Good night.
Night.